us at Thomson Reuters Talks Financial Crime. I'm again your host, Gina Jurva, attorney and manager of market insights and thought leadership for the Thomson Reuters Institute. On January 1st, 2021, the United States enacted the National Defense Authorization Act, or NDAA. Now, in previous episodes, we talked a little bit about why that's important to anti-money laundering or AML reform. Spoke with Brett Wolf, who is a Thomson Reuters senior regulatory intelligence expert. Also talked to Jim Richards, who's the principal and founder of RegTech Consulting LLC. And we discussed some various aspects of the law, including beneficial ownership changes. Well, today joining me to bring the law enforcement perspective is a well-known figure in the AML space, Dennis Lormel. Dennis is a recognized subject matter expert on anti-money laundering, terrorist financing, and fraud. He has 45 years experience in the field, including as the former section chief for the Financial Crimes Division at the Federal Bureau of Investigations, or FBI. Dennis, it is so great to have you on the show today.
Well, thank you, Gina. And I really appreciate the fact that you invited me to share my perspective on this topic. This topic is a topic that's very important to me. As you know, as we've spoken before, I've testified before Congress about the enhancements to the legislation. So I was thrilled to see this enacted in January.
Absolutely, absolutely. And let's talk about that. So the NDAA provides what many are saying is that much needed reform to fight financial crime, which I'm sure you agree with. But I wanted to ask you about a couple provisions, and most specifically that the expanded whistleblower rewards and protection. And the way I understand the new law is that whistleblowers can receive up to 30% of an assessed monetary penalty where the penalty totals more than $1 million. So just to kind of break that down in more layman's terms, why does that matter here? Why is that important?
Well, a couple of things. Let me put two words out there for you. Okay. Incentive and deterrence. And by way of incentive, it's important because especially when it came to corporate fraud, whistleblowers and the tip lines account for about 42 to 45% of all reports. And so if you're in that position where you're going to be a whistleblower, that's certainly an emotional strain. There's a lot personally that goes into that. So the added incentive of the rewards is one thing, but in addition to that, there are protections there against retaliation. And that's, to me, as important as the monetary side of it, because I've seen firsthand a few of these cases, and I've seen what the whistleblowers had to go through. So that's really important. And deterrence in the sense, if I may, deterrence in the sense that somebody who's involved in fraud, and especially in internal fraud, they don't think about the consequences. And perhaps knowing that there's added incentive for whistleblowers, that actually in and of itself is a deterrent.
It's a great point, and we've seen quite a bit around whistleblowers over the past couple years in a different context. But those are really good points. In terms of, there's another key provision I'd love your opinion on, and that's the authorization to obtain foreign bank records from banks with U.S. correspondent accounts. So how will this specifically help in the investigation and detection of financial crimes abroad?
I think this is tremendous. The leverage it gives law enforcement, in that if there's a correspondent account relationship with a foreign bank, right, I can subpoena through the correspondent account for any record in that bank. And the provisions are there where normally they would try to fight a subpoena or something.
Sure.
There are added enhancements here that within 10 days, if they don't comply, the correspondent relationship is to be terminated. So that gives law enforcement a lot of work, gives the government a lot of leverage. Consequently, it gives law enforcement added opportunity to get records we otherwise wouldn't get. So I was the case agent in the Bank of Credit and Commerce International case. If we had this type of authority back then, that would have streamlined the mutual legal assistance treaty process, and we'd have received information on a lot more timely basis. And in today's world, law enforcement needs that information. much more timely because of the urgency of terrorism or transnational criminal activity. So the ability to get access to a broader amount of records and to do it in hopefully a more timely fashion is tremendously beneficial to law enforcement.
Another provision I'd like to ask you about is the provision related to antiquity dealers. Art and antiquity. I guess my question to you is, are we seeing an uptick in arts and antiquities being used to hide illicit funds or to launder funds?
Well, I wouldn't necessarily say an uptick. What I would say here is there has been a long-standing problem here. And where it really manifested itself and gained attention was when the Islamic State set up their caliphate and they got into territory in Syria in particular and Iraq, where they were looting the antiquities. And that brought a lot of attention to this, and especially the fact that the Islamic State was being funded through the antiquities trade. This has been a long-standing problem. That arts and antiquities industry is an industry that really operates on anonymity. So if you're into money laundering or that type of theft, it's a great place to go because of the anonymity involved in it. So this is welcome legislation. I don't think it went far enough because we'd like to see the arts also covered by it, but that's still under consideration.
I see. So the clarification there is that it was specifically is focused on antiquities.
Yes.
Art is separate and not included here.
Well, so yeah, what we have there is there's this, Treasury was mandated to do a survey to determine how culpable the art industry is to money laundering. And when that survey is completed, I have no doubt that they're going to go back and reintroduce legislation that's going to cover the art industry.
That makes sense. What about, in terms of attorneys or real estate agents and accountants, are they included in this new reporting requirement as well?
Generally, no. What they would be included in is if they have any direct business dealings in the art antiquities trade, then yes, they would be covered. But in their positions as gatekeepers or whatever their role is as kind of a third party, no, they wouldn't be.
What is your opinion on the pilot program for sharing suspicious activity reports, also known as SARS, and certain related information with foreign banks, subsidiaries, and affiliates of certain regulated financial institutions? I mean, I think, what I'm hearing is that this is going to help international financial institutions have a more streamlined and integrated global AML compliance function, but I wanted to hear your thoughts on it as well.
Again, I think this is tremendous for law enforcement. It's another break for law enforcement. And the key word here is in the sharing of suspicious activity reporting. So by virtue of the banks being able to, or the branch being able to go back and share that information with other branches and other entities within the institution, that's going to open up lanes for more reporting, hopefully for better reporting, more comprehensive information coming forward to really fill in the puzzle. Because when you think about it, SARS provide tremendous information to law enforcement that law enforcement can use, and those fragments of information help build a case. So the more robust we can make that process in terms of the quality of information being shared, and the other part that you mentioned at the end of the question was the streamlining and integration of an AML process. So when you improve the process, hopefully you're improving the overall reporting and the quality of the reporting.
Any final thoughts before we close just on the NDAA? Anything you think maybe should have been included that wasn't, or are you happy with it in its current form?
I'm very happy in its current form. However, there certainly is a lot that could be added to it. I mentioned the art dealers. So I think certainly the art dealers need to be covered. I think we need to go back. And one of the things they're looking at also is trade-based money laundering. So to the extent that legislation can be passed, because trade-based money laundering, unfortunately, is a growth industry. And so we've got to do something to help improve or to be able to help the reporting of and identification of trade-based money laundering. So that's another one. I think at some point, the gatekeepers, the lawyers, accountants, real estate, you asked about real estate agents, they all need to get covered in some respect. And I think we're moving in that direction. And then maybe unrelated, but related nonetheless, domestic terrorism. I think we need to have legislation regarding domestic terrorism, and whether that has a direct impact or an indirect impact on the financial services industry, it's going to have an impact.
Absolutely, and all very, very good points there. So thank you, Dennis Lormel. Thank you so much for joining us. It's always a pleasure to speak with you, and looking forward to having you on the show again.
Well, great. Thank you, Gina. You take care.